The Supreme Court has decided to hear a case involving a Louisiana anti-abortion law. June Medical Services versus G could help shape the future of legal abortion in America.
We will be following the story every single day this week. Our Kate Smith spoke to TJ2, a lawyer working with the group which brought the case.
At the heart of this case is whether states like Louisiana can regulate abortion providers out of the practice of medicine. In this particular case, the law requires admitting privileges, which is a law that the Supreme Court has already looked at only 3 years ago out of Texas. They struck down the Texas law, and the question is whether the Louisiana law that's identical should meet the same fate.
What is the difference?
There is no difference. The law is identical, and it's not identical by coincidence. It's identical on purpose. So the legislators in Louisiana saw Texas pass this same law, saw it close half the clinics in that state, and said, we want to do that too. So the law is word for word the same. In Louisiana, like Texas, it has no medical benefit for patients, and the disastrous effect would actually be worse in Louisiana. So in Texas, the law closed half the clinics. In Louisiana, it would close all of the clinics except one and leave only one doctor for roughly 1 million women.
What kind of burden does that put on people seeking abortion?
It puts a tremendous burden on patients. For many of them, that will mean that there's literally nowhere to go in the state because, of course, one doctor cannot possibly treat all the women in the state. So plenty of women will have no doctor at all. Women who actually can find their way to this doctor are going to face longer wait times. They're going to push their procedures later into pregnancy. It's going to be more expensive, overcrowded clinics, less time with the doctor. Then many women will have to go out of state, and you have to realize that the campaign to restrict abortion access in the South has been ruthless. So there are very few clinics even in the neighboring states. And what we have to worry about also is that when women have diminished options, some may take matters into their own hands and pursue things that are really unsafe or even illegal.
Louisiana wouldn't be the only state with one clinic left.
Louisiana could become one of about 6 states that's down to only one clinic. And really, that's remarkable, but it's a sign of what anti-abortion activists have been up to for the last decade. While much of the public has been talking about Roe v. Wade, anti-abortion activists have been steadily passing laws that put clinics out of business. So Roe v. Wade stays on the books, but abortion access goes away.
All right, Kate Smith's joining us now to break all of this down. And, you know, this question was sort of answered a little bit in your piece, but Kate, explain why this case is of national significance.
So good morning, Anne-Marie and Vlad. This case is of tremendous national interest because rather than focusing on banning the procedure outright in ways that, many people just find to be blatantly unconstitutional, these smaller restrictions are actually what have been so effective in reducing abortion access all across the South and Midwest. So for this one particular one, it's admitting privileges, whether or not an abortion provider has to be able to, coordinate with a local hospital no less than 30 miles away. On paper, it seems perfectly fine, but the reality is that hospitals aren't compelled to give these providers those admitting privileges, and it's been very, very effective in shutting down abortion care. And what Tu told me is that, even if Roe is on the books, it's perfectly good law, if the Supreme Court holds up this case, you could see a tremendous decrease in abortion access all across conservative states.
So, Kate, isn't the law designed to make abortion safer?
So that's a great question. I mean, the name of this law is the Unsafe Abortion Protection Act, so you would certainly think so. The problem is that, politicians from Louisiana have gone on record saying that they're looking to reduce abortion access. So I spoke to Tu a little bit about how this law plays out, for doctors seeking those admitting privileges. Here's what he had to say.
So let's just take one of the doctors who's actually a plaintiff in this case. OBGYN, decades of experience. He went to a hospital to try and get admitting privileges where he actually had been on faculty for 18 years. And they said, you know, now that you're providing abortion care, we'd really not like to get involved, so no. Then he went to a second hospital, and that hospital said, we'll consider your application, but only if you give us a list of all the patients you've seen in a hospital in the last year. But of course, he hasn't seen any patients in a hospital because none of his patients had any complications, so they refused to even consider his application. So then he goes to a third hospital, and he says, I'm really out of options. I need admitting privileges. And they say to him, there's some people on staff who think giving you admitting privileges, given the nature of your work, would be bad for hospital business. So no. So no fault of his own, he doesn't have admitting privileges, and he has to tell his patients, I'm sorry, I can no longer be your doctor.
Sorry, go ahead, Kate.
No, so you can see what 2 is saying here. You know, it's not by lack of trying that these doctors aren't getting those admitting privileges. It's, you know, a lot because there's so much conservative ideology surrounding abortion access in the state.
So this law, I think, because you've explained to us, comes under the category of these TRAP laws, targeted regulation of abortion providers. There are many of these laws on the books in a number of other states, but not enacted, because of, you know, it's questionable whether or not they are legal. So what could be the impact of this law in Louisiana?
So in Louisiana, if the Supreme Court decides to rule with Louisiana's law, you could see the state go down to just one abortion provider. They have 3 currently. They were actually up at around 10, not even 10 years ago. But if the Supreme Court upholds this, they go down to 1. So today, we're going to actually be talking to a Planned Parenthood here in New Orleans who has been unsuccessful in getting a license to provide abortions. And we're going to share with you tomorrow a little bit about what that looks like to try to get those privileges, to try to get those licenses, and really what the state is doing in ways that make it so difficult for these providers to provide for women this procedure.
And so if the Supreme Court rules in favor of the state of Louisiana, you know, I mentioned that there are a lot of these laws that are on the books in other states, but they're not being enacted. Could we see almost sort of a chain reaction where it could breathe life into these laws in other states?
Absolutely. So 2 told me that he expects to see a flood of anti-abortion regulations, just like the one that you're seeing at the Supreme Court. Again, if the Supreme Court does decide to uphold this law, what that means is that across the South, across the Midwest, places where you've seen state legislators be very proactive about passing these laws, you know, they may or may not be able to go into effect. You're going to see a flood of those regulations, and you could see way more than just 6 or 7 states go down to just one abortion clinic. And Anne-Marie, you could even see some states have no abortion clinics at all.
Wow. Given the importance of this issue, Kate, you're going to be joining us every day on CBSN in the 9 a.m. Eastern hour. We'll look forward to your reporting. Thank you very much.
Thank you.